Hello and welcome to the show that discusses important developments of the day. You're watching The Big Picture. The Cabinet has cleared the long-pending Copyright Amendment Bill after a wait of 2 years. The Copyright Amendment Bill 2010 will be presented in Parliament today. In fact, has been presented in Parliament today. The amendments to the Copyright Act 1958 aim to accord unassignable rights to creative artists like lyricists, playback singers, music directors, film directors, dialogue writers, among others, who will be paid royalty every time the movie they have worked for is aired on any television channel. The amendment bill has faced multiple roadblocks in the past, with some members of the opposition staunchly opposing the presentation of the same in the winter session of Parliament. HRD Minister has also fought very hard for the bill despite stiff opposition from some sections, both from within the cabinet and from outside it. The controversial bill has been delayed because of differences not just with the opposition but also within the government, as differences between ministries of HRD and Information and Broadcasting led to its deferment by the cabinet last month. The two ministries have now resolved their differences and the bill was cleared by the cabinet last week. Tonight on The Big Picture, we discuss the amendment bill itself and the impact it will have on the television and radio industries. We'll also debate whether the bill, if passed, will finally satisfy the artists and creative minds that have been lobbying hard for the changes. And joining me in the studio tonight is Jagdish, Sagar, former member of the Copyright Board. Also, eminent lawyer Neel Mason is with us. We'll start the show, if I could, with Mr. Sagar. Mr. Sagar, the Copyright Amendment Bill 2010 provides independent rights to authors of literary and music works in cinema. The bill also seeks to clarify that the authors would have rights to receive royalties on their work. Why did it take so long for the cabinet to clear it and now being presented to Parliament?
Okay. By the way, I'm a lawyer as well.
Right, right, sir. I beg your pardon, I apologize.
Okay.
Please
now, why did it take so long for the cabinet? I don't think it's taken very long for a bill of this importance, a bill of this magnitude. I wouldn't have been unhappy if it had taken a little longer and there had been more discussion, not of the intentions behind the bill. The government is has very good intentions. Nobody can really dispute the need to protect the rights of the creative people for whom copyright exists. No one can dispute that. But the actual wording of the bill, in my opinion, even at the end of the day, leaves scope for us lawyers. It creates certain ambiguities, a certain amount of confusion as to what exactly it means. So therefore, how the bill is going to work out in practice, whether it will really help authors and if so, how much, is something that we'll have to wait and see. It will pan out in the future.
Right.
I do feel that we can congratulate the government on at least getting this step as far as they have.
Right.
They've been working on it. The HRD ministry has been working on it for a very long time. They've got it to this point. It could have been better, but now that it's being enacted, we will have to wait and see how it pans out.
So you're saying, better late than never?
Well, not necessarily. I didn't exactly mean better late than never.
But you're happy the bill is here now? And
well, I'm glad that at least the field of copyright has got stirred up with discussion. At least people are aware of copyright. And perhaps if more people have rights, then at least it may be better enforced.
Right, fair point.
Finally, we haven't seen the very final form in which the bill has now been introduced. That's not yet available to the public. We'll have to look at it when it comes.
Right, fair point. Let me get Neel into the discussion. Now, the copyright of any work, Neel, is not just going to lie with the owner of the work, but it will also lie with the author of the work. According to the bill, this is the provision that I'm reading out. The owner will also have to share the royalty of the work with the author. The amendment also enables the performer to protect their rights of reproducing them in any medium. Now, on the face of it, this provision seems quite fair and in tune, in line with whatever practices are being practiced internationally, especially, say, Hollywood or international cinema. Why such resistance in India? Javed Akhtar has been lobbying for 2 years, and he wrote in a paper saying he faced opposition from multiple parties and members from within the parliament. Why such resistance in India?
Well, to take a step back, the copyright owners and the creators have never been fractured as before. And obviously there are concerns with lyricists and composers believe they're not getting their due. At the beginning of the program, you mentioned that the rights were unassignable. again, I back Jagdish Sagar and say that I don't have a copy, but my understanding is that it can be assigned subject to restrictions on transfer of minimum royalty that needs to be paid. Now, one of the issues here is that our philosophy has always been that the owner of the person who produces the sound recording or the film, he's the person who takes the economic risk. And therefore, it's not just the lyricist and the music composer who is involved in a, you have a performer, and often a performer pushes it. You have, I mean, in this very studio, we have several other participants.
Right.
And therefore, what does happen is, since it's an economic right, there's an economic risk taken by a particular person, and the rewards of that have been with that person. Now, there seems to be a shift to move away from that, which is causing concern, and to share the revenue. Now, the issue is, do you want to share the revenue across the board? Are you going to share the risk across the board? Clearly, you can't share the risk across the board. So now when you talk about...
Because it's the producer who's taking all the economic risk, isn't it?
Well, that's, I think, the argument of the producers' lobby, that you're taking the economic risk. I don't know statistics, but I think 9 out of 10 movies or 9 out of 10 songs are commercially not viable. And he or she takes the economic risk for that. And therefore, and for example, the author of the sound recording is the producer of the sound recording. And therefore, when you're talking about authors, in a particular song, you'll have a songwriter, you'll have the lyricist, you'll have the music composer, and you'll have the author of the actual sound recording, what we hear. Now, we heard Mr. Javed Akhtar's speech today, and he did mention, I just saw it briefly before the show, that one of the very strong elements is that you have rights in the underlying works, and you have rights in the sound recording itself. And it's interesting that while this battle is going on between the copyright producers and creators and owners as such, a very strong lobby that's now emerged are those who provide the platform, the broadcasters.
Right.
And the broadcasters have recently won litigations in which the litigations have held that when a sound recording is exploited on, say, a radio, then you don't have to pay for the underlying works. Now, these issues are sub judice, and I don't want to get into those. But these are issues that are emerging. These are issues which the broadcasting industry is strongly lobbying.
Right.
These are now, for example, this act itself has brought in the issue of statutory licensing.
Right. We were discussing that just before we started,
And the issue with statutory licensing is, in my view, it will take away the strength that the copyright societies or the copyright owners or authors or lyricists, whoever has a share in that, it cuts down their bargaining power. Now, we have a system in India, in the existing act, which is, in a sense, a check on the copyright societies, by which you have a compulsory license. Now, beyond the compulsory license, we're looking at statutory licensing. So it's interesting that, well, there is a big battle on between revenue share and, that there should be more fairness and there should be more of those issues. One of the biggest beneficiaries of this would be the broadcasting industry. And because there is no united front, in my view, and this is my personal view, but because all the copyright stakeholders are not together, you will have fractured verdicts, and you will have issues like this popping up which nobody opposes.
Let me ask Jagdish, Sagar, do you agree with what Neel just said? And what's your stand on statutory licenses?
Well, statutory licenses, I do think, don't make sense in the Indian context. They exist in some countries where broadcasters really need them. In India, I think the broadcasters are bigger and more powerful companies and much more commercially viable than many of the people whose rights they use. One reason. Secondly, you've got both a compulsory and a statutory license. It looks very odd to me, and there's no evidence that I can see that either is needed, and most certainly that the statutory license is needed. I don't think there's a case for that.
Right.
Secondly, agreeing with Neel's comments, I do think it's true that the authors now, in their attempt to protect their interests, might have got themselves into a situation where they end up actually sharing the commercial risk. The producer, they might well end up in an agreement where their compensation depends on whether the film is a success or not. It could end up like that.
Right. Do you think they had bargained for that when they had started lobbying for it?
I don't know. You see, an author with great market power is going to take an advance royalty or is going to get some payment anyway. But what about the author who doesn't have market power?
Right.
That author is no longer necessarily sure even of the fixed lump sum that he or she used to get, not even sure of it now with the amendments.
Right.
I wonder in the long run whether taking away the freedom of contract actually helps anyone. Granted that one party is often stronger than the other, but taking away the freedom of contract, taking away complete ownership, whether it actually helps in the long run or not, time will tell, but I have my doubts.
Right. Fair point, sir. We'll take a small breather right now. I want to discuss the disparity in the bill that proposes between TV and radio. There's a tilt towards radio. We'll discuss that after the break. Don't go anywhere. Lots more to discuss on the Copyrights Amendment Bill. We'll be right back. Stay tuned. Welcome back. You're still watching The Big Picture. Neel, let me put this to you. The bill proposes to give licenses to radio to reproduce broadcast musical works of non-cinema and cinema free of charge if it's in public interest. At the same time, television has to pay a hefty price to do the same. Why this disparity? What is the rationale behind different approaches towards television and radio? And do you think it's fair to the television industry?
I must say I'm completely blindsided by this statement because I don't believe that the radio industry can, the bill will permit the radio industry to have access to copyrighted material without paying relevant royalty. I think under the statutory licensing scheme, the Copyright Board will fix the statutory license. There have been, the radio industry has been in battle with the copyright industries, essentially the music industry, in compulsory licensing battles that have been going on for close to a decade. And there are some rates that have been fixed in relation to certain copyright owners by the Copyright Board, and there are certain other disputes going on. I think the television industry, there have been a couple of disputes, but I think with the television industry, there has been more private licensing. And as far as I know, none of the copyright licenses have gone to logical conclusions. Perhaps the industry and the music industry have been able to see eye to eye. Perhaps it's because the television industry is financially better or they're more successful. However, the concern now is that if you start bringing the television industry into the statutory licensing scheme, you will now open up another round of disputes which were not really in existence at present.
There has been, the broadcasters, the Television Broadcasters Association has been kind of lobbying hard because the fine is very hefty. If I'm not wrong, it's as high as 1.5 lakh rupees for a 90-second piece. That's a fine if they do it without paying royalties. Do you think that's a little too high? I'll come to you after I get Neel's...
I'm not sure if we have stipulated or statutory damages in the bill. What we're talking about is private contracts and private negotiations. And therefore, you always try and find a balance when things are not private, when you're trying to do it privately. And it's only when the systems break down where you think that, the larger public may be deprived of it because a copyright owner is being unreasonable, that you can look at a system of compulsory licensing. However, the threshold for statutory licensing is completely different.
Right.
And in my view, the negotiations, there would be no negotiations, thereby putting the copyright industry on the back foot.
Mr. Sagar, your thoughts on this?
Personally, as I said, I don't see the real need for either because broadcasters are frankly doing okay. There is no evidence that broadcasters really need more help than they're getting.
Right.
Neither do we have transparency about what the broadcaster earns from the copyrighted material that is broadcast. We don't know what they get by way of advertising revenue, except that it's very substantial if you look at their profits, their annual profit and loss accounts and their annual balance sheets.
They're doing okay, as you said.
Okay. I don't see the need to give them in India this further benefit. And I agree with Neel that commercial agreements have been executed in some cases for copyright owners. We've had cases in court where the courts have decided the question, and they have normally ended up deciding the question in favor of copyright owners. They have normally done so. I think that on the whole, the copyright owners' rights have hitherto been pretty secure qua television broadcasting. There is a real problem for music copyright owners and sound recording copyright owners qua the radio broadcasters. Right. There is a real problem there. And I think the existing legislation has created problems, and I suspect that the amendments aren't going to make things better.
Let me put you another question to you. You brought up the music industry. The critics of the current legislation, the current draft of the legislation, say it might just give the music industry a slight upper hand while dealing with broadcasters. Do you agree with that? Do you think that's going to happen?
I don't think it will give the music industry an upper hand at all. I think it will weaken its hand, and not just the music industry. Remember that now the bill proposes to give better rights to authors.
Right.
The bill also proposes to give more rights to performers. Now, they'll all have less of the cake if you diminish the copyright or rights owners' cake altogether, qua the users of copyright who are broadcasters.
Right.
They all suffer, not just the producers.
Right. Your take on whether it's going to give...
Well, if we're on the cake analogy, my principal concern remains it's not so much while the industry is fighting over who will share the cake, my fear is that the cake is getting smaller.
Exactly.
And there'll be less for everyone around.
Right.
So
exactly.
I think that is a cause for concern for the industry.
Is the current amendment in its current form a fair draft to you? Do you think it finally gets Indian artists and authors and creative minds at par with international terms, not just due credit but also money?
Look, it'll be difficult. You know, the Act is obviously looking at feels that the freedom of contract should really not have primacy in this issue, and it would be fair for anyone to say that there are several contracts that are onerous. However, interestingly, and maybe Mr. Sagar can help us, he was a member of the Copyright Board, and there is a provision under the Copyright Act where an author or a composer may be able to get out of an onerous contract after a certain period of time, if the Copyright Board considers it. And I was just talking to him before, and he's unaware of any such, an author or a composer actually taking such action. So in a sense, there are safeguards within the legislation which have not been tried and tested, perhaps because the authors and composers individually don't wish to, push the legal proceeding, or they're afraid of legal proceedings. I don't know. Do you have any
I have these comments to make on this. Sure. You see, I'm proud to say that I was involved in the 1994 amendments, which introduced this provision, 19A, whereby an author, after 5 years after the assignment, if it's really onerous for him, he has a chance by going to the Copyright Board of getting it rescinded. He has a chance. To my knowledge, at least, no author has ever used this yet. It's also probably true, I don't mean to criticize anybody, of a body I was once a member of. I was only an ex officio member.
Right.
I don't mean to criticize anybody, but I do think the Copyright Board hasn't become as quick and effective a remedy as it was intended to be. Now, when there is a remedy on the statute which is available and not being used, we need to look at that as well as further measures as have been thought of.
Right.
And to be very frank, as a lawyer, I wonder if the bill has been drafted entirely correctly with reference to the intentions of the government and the legislators. Right. I wonder about it, and the courts will tell us in time to come.
In time to come, of course. We'll take another short break here. Closing arguments on this issue by Neel Mason and Jagdish Sagar after the break. Welcome back. You're still watching The Big Picture, and we're discussing the Copyright Amendment Bill that has been tabled in Parliament today. Mr. Jagdish Sagar, let me ask you this. Do you think or to what extent do you think, if this bill is passed by Parliament, will it change the game in the music industry or in the film industry? How is it going to impact? Is the impact going to be as big as some people have hoped if this bill passes?
I do think it will change the rules of the game. It certainly does that. Now, what the impact will be? Will it be as big as some people hope, or as big as some people fear?
Are you going to say time will tell again?
I honestly believe the courts will have to decide.
Okay.
I believe that there is so much scope for dispute about the interpretation of some provisions which the well-meaning intent of which I don't question, that I have to say again, well, I won't say the time will tell, I'll say the courts will tell.
Right. Your closing arguments on the draft. Do you think it's a fair draft, first of all? Do you think it passes muster or will pass muster in Parliament? Also, do you think it'll change the game?
Well, you know, we must understand that the entire industry has changed. In the last 10 years, the revenue models of the entire music industry has changed. 10 years ago, it was on physical sales. It's now switched to radio, television, public performance licenses, negotiations with telecom companies, and that's what's really driving the Indian music industry, and that seems to be and now of course you have, in the last few years, digital downloads on the internet. That's what's driving the industry. And in a sense, yes, certain amendments need to take that into account. Again, I'll take the safe route, as many a lawyer would, and say that the proof of the pudding lies in its eating.
Right.
A lot of it may stand to challenge, but whether it really trickles down to the person who it's intended to, there is a sort of cobweb of provisions, and it's difficult to look at the entire act from a distance. And hopefully some of the issues will be resolved, and the copyright industry will be the stronger for this.
Right, they'll come out on top.
One hopes that the copyright industry is stronger for it, because one must remember that the Copyright Act is essentially for the enjoyment of the public and to bring greater knowledge in.
Right.
And it should benefit the copyright, both the copyright creators and holders.
Absolutely.
It is a fractured industry, but hopefully they'll be able to pull together.
Absolutely. Mr. Sagar, you had a point to make.
Just a quick one, which is that of all the different industries, the music industry, the record-making industry, is the one which is in the deepest trouble globally. Globally, its revenues are declining, and in India, its revenues are not growing like the revenues of copyright users, like broadcasters and the like. The music industry faces a very serious problem because physical sales, as Neel rightly mentioned, no longer what drive it.
Right. Right. That's where we end the program today. Thank you so much, gentlemen, for joining me on The Big Pitch tonight. Jagdish, Sagar, thank you for coming on the show. Neel Mason, thank you so much for joining us on the story. Of course, the bill has been tabled in Parliament. We'll have to see whether it passes muster or not. Of course, as Neel Mason just said, the proof of the pudding will lie in the eating of it. That's all the time we have from The Big Picture on the studio tonight. Till next time, when we get you another hot topic and another eminent panel of guests, this is Athar Khan saying goodbye, good night, and thanks for watching.